This propel we nation moving forward in a new direction. True independence, that's the projection. No more dependency, it's the best plan. Yes, we know what's best for us, cause we want we country prosperous. So make we just pull together as the general public while on the road to Republic Jamaica. Let's spread the word around to let the world know that we are proud to be one republic. We on the road to Republic.
A message from the Ministry of Legal and Constitutional Affairs.
We on the road to Republic.
I wonder who that somebody be. No, sir. Let me look for my glasses. Oh, that somebody look like rice up.
It's Lottie, walk on.
Me glad for see you, Roy. Although things never go on for you, America, me glad say you there.
Yes.
Lift your head high.
Yes.
Stay out of trouble.
Yes.
And you can have a fresh start back home.
Alright, Mr. P. Thanks, you hear?
Let's all work together for a fresh start back home.
The following is brought to you by the Office of the Prime Minister.
Zoom in on the nutrition facts. It there in the table on the side or the back. You fi check out the servings, just do the maths. Not taking too much, finger below the facts. Zoom in on the nutrition facts. It there in the table on the side or the back. Take note of the sodium, the sugars and the fats. 5% or less in the on the right track. You fi zoom in on the nutrition facts. It there in the table on the side or the back. Vitamins, minerals and vitamin 2, 20% and more that good for you. You fi zoom in. Check the nutrition facts. You fi zoom in. Check the nutrition facts. You fi zoom in. Check the nutrition facts. Less sugar, less salt intake and less fat. You fi zoom in.
A message from the Ministry of Health and Wellness, Jamaica Moves, the Heart Foundation of Jamaica, the National Health Fund, and Japan.
People always say government must be held accountable. But is whose job to keep government accountable? And what that really mean? Well, you see, when ministers and public officials have to provide answers for decisions made and can face consequences for those actions and decisions, that means they're being held accountable. Keeping government accountable is a key responsibility of our elected representatives, and the Parliament provides special tools or mechanisms just for this. As citizens, we need to understand how they work so we can play our part to ensure that the members of Parliament we elect are using the tools and doing their job well. Here are 4 of the primary tools you should understand and talk to your MP about. Tool number 1, Ministers' Statements. To effectively monitor the government, MPs need to stay informed. Every Tuesday when Parliament sits, different cabinet ministers are scheduled to give an update on decisions they're making on our behalf. These updates are called Statements by Ministers. They cover a wide range of national issues that other MPs, media, and citizens may have questions about and wish to examine further. That brings us to tool number 2. What do you do when you want information? You ask questions, and that's why we have question time. Both opposition and government MPs can submit questions to the Prime Minister or Cabinet Ministers for details on, for example, how a contract was awarded or expenditure to purchase tablets for schools. So if you ever have a question for a government minister, try asking through your MP. After all, that's why they're your political representatives. They should represent your questions and concerns to the government. Tool number 3, Parliamentary Debates. When cabinet ministers present the government's proposals for new policies, laws, and programs, parliamentary debates allow both opposition and government MPs to air concerns, make suggestions, and endorse proposals. If you ever watch those debates, you know they can get a little fiery. But the debate is important as it informs decisions and continues until a vote is taken on the way forward. Then we have tool number 4, Parliamentary Committees. The general sittings of Parliament are not always sufficient for detailed examination of government work, so oversight committees are formed using government and opposition members to do just that. Some committees like the PAC and the PAAC are in place for an entire parliamentary term. Their job is to monitor the use of public funds to find ways to increase value and efficiency while reducing waste and corruption. Cabinet and state ministers are not appointed to oversight committees since they are a part of the government. Some committees are formed when a need arises. For example, joint select committees are formed to review draft policies or legislation or to probe other matters of serious national importance. Members of these committees are both opposition and government MPs and senators, and these committees will usually invite citizens to share their opinions, concerns, and recommendations. So there you have it, 4 accountability tools of Parliament that are used to make sure government run right. Visit jampja.org to find contact information for your MP. Invite them to meet with the community so they can better represent your issues and concerns in Parliament and keep government accountable. Get involved and let's make Jamaica land we love, Jamaica land we own, and the Jamaica land we run well. A message from the Jamaica Accountability Meter Portal, funded by the European Union and the Inter-American Development Bank in partnership with the Private Sector Organization of Jamaica.
I guess I'll ask Minister Marissa Dalrymple for the second vote minutes, okay? If there are no matters arising, we're going to go straight to the matrix, which we have been considering for the last few meetings. We're hoping we can complete, but if we can't complete, then we may have to have another sitting of the committee. Let me also welcome all the members who are here from the Office of the Child Diversion. The Children's Advocate is here, no? Yes. The CPFSA, welcome from the Ministry of Education. Attorney General's Chambers, Ms. Carissa Melido. Ms. Ada, may I just thank you for your 18-page opinion. I read them on the plane coming home last night, so yes, and thank you for that. I hope other members had a chance to read them. And we have a number of other comments later on. But I think we should just go straight into the matrix. And then we see how far we can get. And then towards the end, if we don't finish the matrix, by about 12, we're going to go back and deal with those matters which we should have completed at the last sitting. But let us see where we can with the matrix. And then if we, by 12:30, we see what happens. Yes, Senator Goldenkamp.
Thank you, Chairman, and good morning again. You indicated that we are going to be dealing with that there were no matters arising from the minutes. Given the opinion of the Attorney General's Chambers, and there was an opinion from the Legal Reform Department that was shared at 9:13 this morning, I'm still going through that. Are those not the matters arising, or is it that you wish to deal with those at a later stage?
The truth is that I'm aware that persons have not yet completed the reading, and I know the law reform and also the Child Diversion Office should have sent further comments. Were they circulated, Mr. Nash? All right.
We received the AG's opinion and the LRD's opinion. I haven't seen one from the Child Diversion Office itself.
Mr.
And I also asked a follow-up question via email last evening, which I'm not sure if they had a chance to see.
The truth of the matter is that is why I said if we could leave that until around 12:30.
Okay, very well, very well.
You see, because they may take a little time, and I said, let us see where we can get, because we were almost finishing the various sections of the act. Where were we? Can you remind me, Mrs. Koljarth or Mrs. Shanique? Huh? We were 32? Page 42? All right, part 1. At page 42. 47? Okay, and then in part 2, we were at what page? At page 38. So we don't really have that much to finish up. And as soon as we finish, we can go back to the matters arising from the last, and then also touch on some other issues that were left incomplete. So you're going to take us through, who is going to do it? You, Shanique, or go ahead.
Hi, morning, everyone. So we're just going to pick up where we left off at the last sitting, which was to just read the sections of the Act and then read the various stakeholder comments that we would have gotten on that particular section. So at the last sitting, we would have stopped at Section 31 of the Act. So this morning, we'll start at Section 32. So
that deals with the consent of the victim.
Yes, Minister.
Yeah, go ahead.
Right, so Section 32, dealing with the consent of the victim, reads 32.1, subject to subsections 2 and 3, where a victim consents to A, the issue of a formal warning or a police caution, or B, the referral of a child to a child diversion program, that consent shall be in writing, signed, witnessed, and recorded in the prescribed form or manner, if any. Subsection 2, where there is more than one victim, the consent of each victim is required. Subsection 3, in any case where the victim is a person under the age of 14 years, consent for the purposes of this part may be given on the victim's behalf by 1, the victim's parent or guardian, 2, the children's advocate if A, the parent or guardian cannot be located, or B, the court or the constable, as the case may be, is satisfied that the parent or the guardian is or appears incapable of giving consent for the purposes of the Act by reason of any physical, intellectual, or mental impairment, and B, a person who has attained the age of 14 years and who the court is satisfied is unable to give consent.
Okay, all right, so you can continue. We can, what were the comments on that section 32?
All right.
The comments?
Mm-hmm.
Comments from the Office of the Director of Public Prosecution. The schedule lists diversion offenses, while Section 37, subsection 2, grants judges discretion to divert other offenses in the interest of justice. However, the Act does not specify criteria for exercising this discretion. Judges currently apply Section 9 criteria by default. It is proposed that Section 37 diversions should explicitly meet Section 9, subsection 2 criteria.
Can we make a note of that when we get to Section 37, okay? So that were the comments on
yes.
Section 32. So when we get to Section 37, we see what further guidance can be given to the judges, okay?
That's the extent of comments for Section 32,
Okay,
Minister.
so 33 now then. Which is the next section?
33.
Section 33 speaks to court warnings and orders. So warning by the court, so Section 33.1 reads, where a child is charged and brought before a court in respect of a diversion offense, the court may 1, hear the case, 2, issue a warning to the child and suspend the prosecution of the case if the court is satisfied of the matters set out in subsection 2, refer the child to the child diversion committee for the parish in which the child resides for participation in the child diversion program, or adjourn the matter, or adjourn the case, signed I. The court, on consideration of the matters set out in subsection 3, may issue a warning where it is satisfied that A, a child is charged with a diversion offense, B, the child has entered a guilty plea,
And this is, go ahead, read it. B.
and C, the child has not previously been charged or convicted of an offense.
No, well, this is where, Mr. Manti, we are going to have some adjustment, because bear in mind, we are hoping that this will only apply to non-diversion offenses. In other words, where there are diversion offenses, we are hoping the DPP and the clerk of courts will not allow this matter to go to court. Okay? So this would only apply where, it's a matter that is not in the schedule of child diversion offenses, and the judge sees it fit because it's a child that they could benefit from child diversion. Okay?
Or perhaps where the child has failed.
Or the child has not really complied
the child
with
diversion.
all the child diversion
Attempts.
regime. Okay? All right. I think we get an idea of what that is indicated in Section 33. So we're going to continue, Shani, what the other comments?
Comments from
I'm so sorry. Can I just ask a quick question?
Sure.
In relation to 33 and that specific subsection that you're talking about, if we're saying that this is applying to non-diversion offenses, then it's really not a part of this act, is it? It's really for the court in the normal process of the criminal justice system.
Well, this is where Ms. Eaton is going to assist us, and that is what I'm hoping, because it may well be Senator Sharon Golden Campbell, because if the child fails to comply with the regime proposed by the Child Diversion Office, the child may well have to return to court. Sorry, Ms.
To clarify, Mrs. Golding, it is in the act where the court has a discretion to go beyond the first schedule. So you have a first schedule of offenses that are listed, and then it says that in that same first schedule, at the discretion of the court, any other offense that they may take into account. So I think maybe Minister's reference is to those other offenses that in the court's discretion that are not specifically listed in the schedule, that the court could consider the child for diversion.
Very well. Thank you so much.
Right. Yes, Ms. Ryan.
Morning, Chair. Morning, members. Morning, technical team. I'm just wondering if there could ever be a scenario where a child may very well have been charged with a child diversion offense, but is insisting that they're innocent. And so, in other words, I don't know if this section should be limited to or applicable only to matters that are non-divertible. Because
No. I said it will also include diversion offenses, because it may well, as you quite rightly put, take cases where the child has not really comply with the regime of what was proposed, for the child diversion. And I think I made another point where the child insists that he or she is not guilty.
Okay.
You get me? And in that case, the child may well have to be tried.
Right.
Okay?
Okay.
Okay, so continue, Ms. Graham.
Comments from the Ministry of National Security and Peace. In relation to Section 33, subsection 1, the Ministry recommends that regard be had to the intention of the Child Diversion Act, pursuant to Section 2, subsection 3 of the Act. In its current form, Section 3, subsection 1 does not limit the court's discretion to first explore referring a child who has committed a diversion offense to the Child Diversion Program. The Ministry recommends the removal of Section 3, subsection 1, subsection D of the Act, as the effect of an adjournment of a case sine die runs contrary to the overarching effect of the Act, and as the best interest of the child, in that it creates a dated log in the court process where, until further findings are provided for the court's consideration, the matter concerning the child remains off the court's record for an indefinite period, possibly resulting in the child being lost in the process or the system.
Yes, I think this is where, Ms. Eaton, you will help us. Please, the drafter will help us to see if this is really how we fit in with the different scenarios, okay? All right, thanks.
Comments from the Ministry of Justice and Constitutional Affairs. If the option of adjourning a matter sine die is to remain in the Act, Section 1, subsection C and subsection D could be merged. The merger would require removing the word or and provision for subsection C, and in merging the provisions, indicate that where a child is referred to child diversion under subsection 1, subsection C, the court may adjourn the matter pending the outcome of the child's participation in the child diversion program. Section 33, subsection 3J could also include the risk posed to any victim or a new subsection 3K to address this. There's an obvious distinction in provision, section 33, subsection 1, subsection C, section 37, subsection 3, and section 28, subsection 1, with section 37, subsection 3, and sections 33, subsection 1C, having broader scope where the offense was committed or where the child resides, and section 28, subsection 1, which restricts consideration solely to where the child resides. This distinction invites a further examination into the reason for the distinction and the possible implications of each approach.
I think it's a fair position. So, Ms. Eden, again, this is for the drafter we accept the proposal. We see where we can go with it.
Comments from the Ministry of Education, Skills, Youth and Information. We recommend that Section 33, subsection 1D be deleted. This is on the premise that such indefinite adjournments runs the risk of a child being lost in the system. Further, this contradicts the principles of the best interest of the child, as well as the spirit of the Act, which includes a matter being treated without undue delay. It also goes against the overriding objective of the judiciary, as well as the principles of differentiated case management, otherwise referred to as DCM, in having matters dealt with expeditiously, judiciously, and with the requisite sensitivity.
That's it?
No, Minister. So on part 2.
No, before you go ahead on part 2. No, before you go to part 2, I think you know, both the Ministry of National Security, Ministry of Justice, and the Ministry of Education have some concerns in relation to those sections, whether we merge them, whether we eliminate them. At the end of the day, the main consideration is how we juxtapose it with the idea that once a child goes on a child diversion program or is referred to the child diversion program, they're not necessarily going to go to court. Because as we have discussed before, if the child is charged, then we are hoping that the court, the DPP or the clerk of court, will not take the child to court. The child will go straight to the child diversion. However, if the child refuses and doesn't want to go to child diversion, as Ms. Wright has pointed out, may say, I'm not guilty, or I don't want to go on in the child diversion program, then these will have to be taken into consideration. And I think the point posed by the Minister of Education, is a good point. We don't want an adjourn, and in fact, the court no longer uses the adjourn sign it down. The court actually now finishes the matter. So bear that in mind, Ms. Eaton. We can remove that section that deals with adjourn sign it down, because the court no longer uses that provision. The matter must come to an end. And as we know from expungement cases, there are far too many matters that remain in the courts because they were adjourned sine die or they had no various things. What the courts have now decided that once a matter comes to court, it must be completed. So that the question we need to look at in Section 33, the idea of adjourned sine die or putting it off until must now be eliminated. So Section 33 needs a fair amount of revision to comply with what is now happening in the courts and also what we have decided and what was suggested by the DPP, that if the child wants to go on child diversion program, then the child will not even end up in court, okay? But we do have to remain, the section will have to remain for those cases where the child pleads not guilty or where there are other offenses that the court may well refer to child diversion, even though it is not in the schedule. So, continue, Ms. Graham. Part 2.
There is one other comment from Jamaicans for Justice in relation to Section 33. They're proposing to insert a new subsection, Section 33, subsection 5, as follows. Where a court refers a child for diversion under Section 9 of or Section 33, subsection C of this Act, the court shall A, adjourn the proceedings without taking a plea and shall refer the child to child diversion program. B, a court shall not record a plea, conviction, or a guilt for finding of guilt prior to or as a condition of such referral. And C, any plea taken in contravention of this subsection shall be of no legal effect and shall not be admitted in evidence. That's the first part of
Right.
JFJ's
Yeah, go ahead.
recommendation.
You wanted to say something, Ms. Cooljarrett?
Yes, Minister. So we hadn't gotten to that part in terms of reading. So what Section 33, subsection 2 would have indicated was that in order for the court to issue a warning, the child has to enter a guilty plea. So in
Right.
terms of the Act, that's the only section that uses the words enter a guilty plea.
And as we have indicated, it will be fully readjusted. But go ahead, Ms. Graham. So we take into consideration what was recommended by Jamaicans for Justice, but in light of certain decisions that were taken, especially the suggestions from the DPP, the likelihood is that most of Section 33 will either be eliminated or adjusted or merged, okay? Because bear in mind, Section 33 involves a court process. And as we have intimated, once the child goes on a child diversion, the likelihood is that Section 33 will not apply. In most cases, at least. All right, so that's Section 33.
Well, they have a second part to their recommendation, Minister. They're proposing to insert a new section, Section 33A. It should read as follows. Where a child is charged and brought before a court in respect of a diversion offense, the court shall, 1, deal with the matter exclusively within the jurisdiction of the Children's Court, and 2, before any plea is taken, the court shall consider whether the matter is suitable for referral to the child diversion program. 3, where the court is satisfied that the matter is suitable for diversion, it may make an order under Section 33, subsection 1C. 4, nothing in this section prevents the court from adjourning proceedings to obtain information relevant to the diversion assessment. 5, where a court has successfully completed a diversion program in accordance with the Act, or where a child, no criminal record shall be created or maintained in respect of that child. 6, upon receipt by the court of confirmation from the Child Diversion Committee or the Child Diversion Office that a child has successfully completed the program, the court shall record the completion of the program and order that the matter be closed. 7, the disposal of a matter under subsection 6 shall be administrative in nature, and the attendance of the child before the court shall not be required.
Quite. So just to reiterate what we have been saying, on the Schedule 1, under the schedule for child diversion offenses, the likelihood is that the child will not be in court. So as Mr. Wright pointed out, if the child may well be in court, if they are pleading not guilty, they say they're denying that they commit the offense, or there are offenses which an attorney may bring to the, or even the DPP, to the court's attention, or children's advocate as the case may be, that it is one in which is not in the schedule as a child diversion offense, but it would be appropriate because of the nature and circumstances of the case that the court may exercise its discretion. And in all sincerity, we can't really determine how the court exercises its discretion. We are going to leave it to the court to exercise, if it sees fit to exercise its discretion to refer the matter to the child diversion program. So, Ms. Eden, you need to just capture for us what has been discussed, okay? So 33 should remain, but much of it will be removed in relation to child diversion offenses, save and except where the child is there in court for a child diversion offense, but is pleading not guilty, and also those offenses where the court is being asked to exercise a discretion that the child be referred to the child diversion program. Okay, and that's Section 33. I think it's a very important section because it is one in which that has given a lot of trouble to the judges. I must tell you the truth, okay? I have had meetings with judges, and Section 33 makes the point. The child pleads guilty. And we're saying from Section 9 that in Section 9 we don't expect the child to plead guilty because when they plead guilty they have a record. But Section 33, in many ways, contradicts what is said in Section 9. So we need to really work it, Ms. Eaton, so that Section 9 and Section 33 are not in conflict. Well, it's a question, some of it has to be eliminated. For child diversion offenses, it should not be there, save and except where the child is pleading that they are not guilty, they weren't involved. But then also where the discretion, and it is provided, where the court is being asked to exercise the discretion to provide the child with the program, even though it is not one of the scheduled offenses. And I can tell you from the very beginning, we did note that this Section 33 was a troublesome section, and as can be seen from the different recommendations from the ministries, from Jamaicans for Justice, it is a matter, Ms. Eaton, that we should look at carefully how we revise it going forward. Okay? So that's Section 33. All right, so we move to Section 34. Welcome,
Mr. Chairman,
welcome, Mr. Member Buchanan and Member Leander Dixon. Yes,
Yeah, just before you move to 34, Mr. Chairman, Section 33, subsection 1, starts with dealing with matters brought before the court in respect of a diversion offense. Subsection 2 speaks of the court's considerations of matters set out in subsection 3, and subsection 3 discusses what the court must consider when determining whether to issue a warning. And if you look at what falls under subsection 3, the matters that fall under subsection 3 for the court's consideration in determining whether to issue a warning read to me as matters related to offenses that are prescribed offenses, i.e. diversion offenses under this act.
correct.
I'm asking for some clarification from anyone who can assist me. 33 is not intended, in my view, to deal with non-diversion offenses. We're not prescribing for the court what it must do in relation to non-diversion offenses under 33. So I'm concerned that we are conflating matters or mixing matters not intended to be mixed, and I'd appreciate some clarification. Thank you.
We are. You're quite right, Senator Golden Campbell. What we're saying is that we are still going to allow the court to consider a child diversion program, even though it is not a child diversion offense. So we are now saying that for child diversion offense, and this is where the drafter will have to help us, that for child diversion offenses, the matter won't necessarily come to court, because we are hoping it will be referred directly to the child diversion office before it comes to court. But it can come to court in two ways for child diversion offenses. Firstly, where the child is saying he or she is not guilty, and therefore the matter will have to be dealt with by the court. And secondly, where we're not guilty, or secondly, where the child has been put on the child diversion program but has not complied, and therefore the matter has to be returned to court. Okay? So, and then the third point, the point you are raising, Senator Sharon Golden Campbell, we want Section 33 to capture the area of the non-child diversion offenses, which we're hoping that the court will exercise its discretion to do. Yeah, go ahead, Ms.
Right.
One second. Yes.
I was actually pointing out that Section 37.2 of the Act actually has that provision.
Section 37?
37. So if you have the Act before you, Section 37.2 reads, notwithstanding the diversion offenses specified in the first schedule A court may make a child diversion referral order in respect of any other offense in the interest of justice.
Ah,
Right.
so
Thank you. And that chairman was what prompted my question. Because I thought if we have 37.2, we're mixing up 33 if we're considering.
And I am totally, as usual, wrong, right?
No, Chairman, I would not say that at
So
all.
in other words, I'm going ahead of myself. So, Ms. Eden, what has to happen in 33? It may well have to refer to 37 for the non-child diversion offenses. Okay, Senator Sharon Golden Campbell. Yes, Ms. Eden.
Thank you, Chair. I just thought it would be useful for us to remind ourselves what a diversion offense is. A diversion offense means an offense specified in the first schedule. B, any other offense for which a court may make an order referring a child to participate in a child diversion program. The distinction between first schedule and any other criminal offense committed by a child is with reference to who may make the referral. So there is no, in other words, once a child commits a criminal offense, it is a child diversion offense. It's just that the offenses that are listed in the first schedule are the ones that can be dealt with by the constable.
Thank you, Ms. Eden. Thanks for that clarification. That's a nice nuance to the point. Yes, go ahead.
You know, Chairman, you're making me lose the opportunity to sound bright, and my classmates are taking all of the salient points from me.
But you don't need to tell people you're bright, we know.
I just was saying, but I want to look bright on TV, Chairman. Anyway, but Chairman, I just want to bring to the attention that there is some overlap.
Yes.
So while I was listening to the conversation, albeit I apologize for my lateness, Section 33, and I have my notes here, and I also looked at the recommendations. I'm just hoping that we can address some of the things that might be problematic when we read the sections across the Act. For instance, this warning, there's like Part D. Things that need to be removed is the adjourning the case sine die and the effects of that. Removing that. But also, we know the court has the option to hear the case, and there's an aspect of it about issuing a warning to the child and suspend the prosecution. The suspending of the prosecution that also have the effect of having it hanging over the child's head, and so the language is something that we want to correct. This is where, and I know that Senator Golden is listening, and I was trying to whisper to you, Chairman, but I think that I'm now wondering if this aspect about first schedule offenses and mandatory child diversions, if it would take it out of Section 33, if there are aspects of it that we say we don't necessarily need consent from the offender or the victim, and if there are some diversion offenses that go straight to child diversion, then Section 33 would be a discretionary section for the court's power only.
If you don't mind me interrupting,
sure.
If you listen to Ms. Eden, that's the point. Ms. Eden makes a point quite correctly that the first schedule lists a number of child diversion offenses where the constable can warn in caution or charge, and if charged, the DPP can also refer to child diversion. So we are hoping that for those that are listed in the first schedule, the child doesn't go to court.
I know, Chairman,
right.
But what I'm saying is, you notice that we are contemplating layers of discretion, constable, DPP, and the court. We're saying that if as drafted, as a committee, as the legislators guided by competent drafters, if we are finding a mechanism where some of this is mandatory, it doesn't apply, because there will be situations where, as an officer, I won't exercise that discretion. Me no know if I do, and I pass the baton. It goes to the DPP, and she says, let's leave it for the judge. But then it also opens the discretion to whether or not the right mix of Starbucks was given that morning.
My hope, and I just expressed my personal position, is that in relation to the child diversion offenses, they don't go to court. Only at all.
That's
only
right.
if the child challenges that they did not commit the offense, or secondly, they did not complete the child diversion program appropriately. So that the only time a child would go to court are in those two cases, or they have committed an offense that is not in the schedule, and you're asking the court to exercise its discretion on the 37.
I'll take that point.
All right.
Thank you.
All right, I think that's fairly clear now. So we move to 35, is it? 34? 34.
So Section 34 of the Act speaks to court orders. So Section 34(1) reads, where a child is brought before the court as a child in need of care and protection under the Child Care and Protection Act, or as a child offender or otherwise, the court may make an order under subsection 2 in respect of the child if satisfied that it is expedient so to deal with the child. Subsection 2 reads, an order under subsection 1 may, A, require the child to make amends for the loss or injury caused to a person by the child, including by the rendering of services by the child directly to the victim who sustained the loss or injury, as the case may be, if that victim consents to receiving the service. B, if there is no identified victim to whom reparation may be made, under paragraph A, require the child to make amends by rendering services to the benefit of the community. C, hereinafter referred to as an order to make amends. C, require restitution subject to such terms and conditions as may be specified in the order. D, refer child to the Child Diversion Committee for participation in a child diversion program, hereinafter referred to as a Child Diversion Referral Order. And finally, E, suspend the sentence of a child who has completed a child diversion program so that the sentence will not take effect, hereinafter referred to as a suspended sentence order.
All right, both the Ministry of Education and the Jamaicans of Justice had concerns with this section 34. Ms., you would like to?
The Ministry of Education, Skills, Youth and Information, their recommendation is in relation to section 34 to 36 of the Act. In regards to court orders, reparation orders, and orders to make amends, we therefore recommend that the provisions be revisited to include a child in conflict with the law, together with a child offender under section 35, subsection 1A, and section 36, subsection 1A, as well as the matter of the offense being alleged, as well as proven under section 35, subsection 1B, and section 36, subsection 1B, as the case may be. Further, in light of the removal of the reference to a child in need of care and protection, reference to a children's officer under section 35, subsection 1, and section 36, subsection 1 would need to be deleted. This is on the premise that children's officers, as per the Child Care and Protection Act, would only have jurisdiction to act in circumstances where a child is deemed in need of care and protection. The Jamaicans for Justice recommendation.
Sorry, the Ministry of Education continue. Oh,
well,
no, that's
it's in relation to section 35 and 36,
right.
Minister.
So we can get to them. What Jamaicans for Justice said?
Jamaicans for Justice is recommending that repeal all references to a child in need of care and protection under section 35 or 34, or amend section 34 to clarify that children primarily in need of care and protection are referred to the CPFSA and not to the diversion program.
Right, I think there may be merit in that argument. There's, yes, there's merit in that argument. In other words, we have been conflating these two programs, and therefore I agree with the Ministry of Education and the Jamaicans of Justice that any reference to the child being referred to the child care and protection should not be a part of this act. This act should only be concerned where the child is in conflict with the law. So we are going to streamline it throughout in that way. Yes, Mr. Ranton.
Minister, I'm just going back in my memory, and because as you had pointed out at the last sitting, I was there from the beginning. My recollection is that the inclusion of children being in need of care and protection alongside the child offender under court orders was because it was to capture children who were below the age of criminal responsibility, who may have committed what would have been a crime but could not be charged with it. And this section was to empower a regular children's court judge sitting to pick up, to be able to do the reparation order, to be able to do an order to make amends for even those children below 12 to have these orders be done. That was my recollection.
But with due respect, Mr. Wright, it really should go straight to the Child Care and Protection Act. In other words, why put it here for the Child Diversion Office to say, no, it's not for us, it is for CPFSA? So that if we leave it there, the court may well be wondering what to do. We should make it clear that a child under 12 is not going to be a part of the Child Diversion Program. It must go straight to the Children's Child Care and Protection Division. So I agree that we should remove all references to child care and protection in the bill. Okay, that's section 34. 35, which is the same thing. If you ask me, both 35 and 36 keep referring to Child Care and Protection Act. And this is where we want to streamline between 34 and 36, that we are only referring to children who are in conflict with the law and who can be referred to the Child Diversion Program. All other references to children should be going straight to the Child Care and Protection Division of the Ministry of Education, okay? So I would, without even reading them, Ms. Colgard, let Ms. Shanigrim deal with what was said, because it captures what is in those sections. Go ahead, Ms. Shanik.
So are we moving to 36, Minister? Or
No, we just
on
deal with 34 to 36. Okay. They're dealing with the orders.
So 37, so we'll read section 37.
No.
Yeah?
I want you to read what the Minister of Education and Jamaicans of Justice said in relation to 35 and 36.
The Ministry of Education, under section 36, order to make amends, and the recommendation is in relation to 34.
Go to from section 35 and 36, the Ministry of Education.
Okay, Minister. Reparation order. The Ministry of Education scales youth and information. Section 34 to 36, in regards to court orders, reparation orders, and orders to make amends, we therefore recommend that the provision be revisited to include the child in conflict with the law together with a child offender under section 35, subsection 1, and section 36, subsection 1A, as well as the matter of the offense being alleged, as well as proven under section 35, subsection 1B, and section 36, subsection 1B, as the case may be. Further, in light of the removal of the reference to a child in need of care and protection, reference to a children's officer under section 35, subsection 1, and section 36, subsection 1 would need to be deleted. This is on the premise that the children's officers are, as per the Child Care and Protection Act, would only have jurisdiction to act in circumstances where the child is deemed in need of care and protection. So that comment from the ministry.
Go ahead and read the section 36, on 36 from the Ministry of Education too.
Under section 36, order to make amends. In regards to court orders, reparation orders, and orders to make amends, we therefore recommend that the provision be revisited to include. So, Minister, it's the same recommendation copied and pasted.
Okay. Yes, I see. All right. Read Jamaicans of Justice now then. they make the same recommendations. Part 2.
From the Ministry, from Jamaicans for Justice on Section 35.
Yes, go ahead.
There are no comments from Jamaicans for Justice on Section 35 or 36, Minister.
Yes. Go ahead.
So we are now at Section 37.
Right. So basically, when we look at 34 to 36, it is conflating, what CPFSA is responsible for, and that it is a child diversion program should, in a sense, be referring the matters to them. So most of 34 to 36 might well be repealed or amended, as the case may be. Okay? So we go to 37, which is, we dealt with. Right, and 37 is the residual clause for offenses that would be in the discretion of the court to refer to child diversion because it is not in the first schedule. And that, as we pointed out, Ms. Eaton, will have to be reconciled with Section 33 so that there's a quick, or should I say, we know what is the court's responsibility as against what can be referred directly by the constable or the DPP straight to the child diversion offices. So we can then go straight to 38.
Section 38 of the Act speaks to suspended sentence order. The court may make a suspended sentence order if the court is satisfied that a child having been referred to a child diversion committee for participation in a child diversion program under Section 34 has completed the child diversion program in respect of the diversion offense for which the child has been convicted and sentenced.
And this is where I would say we need to amend that section. Here, what we're saying, you see, is on the Section 37, it's a non-child diversion offense. It may well be that the child is found with a toy gun, just to use an example. We don't want the child to have a criminal record. And if the child pleads guilty, even and get a suspended sentence, that child will have a criminal record, and that may not be suspendable, because under the Expungement Act, it can't be expunged. So we need to point out that where the court intends to exercise its discretion to refer a child to the child diversion program, that the court does so and allow a period of 3 to 6 months, as the case may be, to see if the child complies with the child diversion program, and if the child returns and the child diversion officer can show the court that the child has not, should I say, has rehabilitated or successfully completed the program, urge the court to dismiss the case. So we need to put it that way, Ms. Eaton. In other words, what you're saying, Ms. Eaton, is that we don't, how Section 38, in pursuance of Section 37, gives the impression that the child will be found guilty or has to plead guilty, and therefore will have a criminal record. And we're saying that that is not the intention overall of this act. So we need to find a way to, guide the court accordingly. Go ahead, Ms.
Thank you, Chair. If memory serves, there was earlier discussion by the committee pertaining to this provision in the context of the scope of this act, which was that it should not operate in relation to a child who had been convicted. So earlier, if memory serves, the committee had considered the deletion of Section 38 consistent with the earlier proposal that the reference to a child who had been convicted should not be within the scope of this act.
So, colleagues, as Ms. Eden pointed out from the discussion and the recommendation, the likelihood is that Section 38 could be deleted. And Ms. Eden is suggesting that is for our consideration, and I would support it. Yes, Mr.
I'm supporting and reminding that I think we had a lot of discussion surrounding this, and knew that that particular section was a transitional period. And I think that that transition is over.
Absolutely.
And it should be removed.
And removing it reflects a lot of what we have been discussing.
That is so true.
So the answer is yes, Ms. Eden. The recommendation is that Section 38 should be depleted. Senator Golden Campbell, you...
I don't have anything further to add. I was just registering my agreement as well, Chairman.
Thank you very much, Senator Golden Campbell.
And just to say, Chairman, that I think it was actually reflected in the minutes of June 3rd.
Wonderful.
That recommendation.
Thank you very much, Ms. Donna Scott Motley. So that is Section...
And I also want to record my approval of that section to be removed as well.
Thank you very much, Minister Flynn, Cuthbert Flynn. So we now move to 39, and we can really just go straight from 39 to the end, okay? All the remaining sections. Just these are basically administrative matters, right? So we effectively would have completed, you know, the bill in terms of the assessment. Now, is there anything else, Ms. Graham? The schedule? Sorry.
Just equally the complete removal of Section 44. And I think that would complete 44.
Could you read it for me, please?
So Section 44 deals with the transitional provision, and it reads, subject to the provisions of this section, with effect from the appointed day, the provisions of this act shall have effect and apply in relation to a child offender, young inmate, or parolee who was a child at the time of conviction, as if the act were enforced at the time. A, the child offender was brought before a court. B, the young inmate was sentenced. Or C, C, of the grant of parole. And 2, notwithstanding the provisions of the Parole Act or any other enactment in respect of a person who was a child offender or young inmate at the time of the grant of parole, the parole board may amend the requirements of the relevant parole order in respect of that parolee in accordance with this act as if it were in force at the time when the parole was granted. And subsection 3, in this section, young inmate means an inmate under the age of 18 years.
Okay. Now, just for reference, Miss Venetia Phillips is not here. Do you know of any cases that were dealt with of children who were convicted and in the last 5 or so years and who were institutionalized? You're not aware, Ms. Tashon?
Any such circumstance?
No. Yes, Ms. No, we're talking about persons. We're talking, you see, I think this act had anticipated that there may have been juveniles who were convicted and who could have benefited from the child diversion program.
I have a young child who was convicted of an offense, and from a school in Trelawney.
The challenge we have, you see, the challenge we have is that in most of those cases, you can't remove the guilty plea. You know, that is why we are trying to avoid a guilty plea going forward. So this act was hoping, I can put it no better than that, in the transitional program, that the child would have gone through a child diversion program even after conviction, and that may well assist that child in getting an early expungement. So I agree with Member Buchanan that we can remove now Section 44. So if there are no objection, everyone, we will also recommend that Section 44 be removed. Okay, finally, the schedule. Sorry, go ahead, Senator Sharon.
Chairman, I would like to just ask the committee to look at Section 43. I think the only comment on Section 43 came from the Jamaica Coalition for a Healthy Society. This act, Chairman, was passed in 2018, and I do believe this is the first review of the act. 2018 and 2026, of course, makes that 8 years and not 3 years. We often, Chairman, put these provisions in legislation. I've been seeing them certainly for the last 20 years, that we are indicating in the legislation that it must be reviewed within a particular statutory period. But it is more often observed in the breach than it is complied with. And there is no consequence to anyone, neither minister nor ministry nor office, for failing to bring the review of the act to the Parliament. I raise this, Minister, not to create unnecessary sanctions for public officers, but simply to say that we have a duty to monitor legislation, and we have a duty in the Parliament to ensure that it is reviewed in a timely fashion and that it receives the scrutiny of the officials sent to the Parliament by the people.
I think
And
you're
so
correct.
I am asking.
No, I think you're totally correct, Senator Shireen Golden Campbell. So,
I'm not Chairman lambasting anybody here. I'm simply asking that we look at 43. This is now requiring that the legislation be, the first review should have been 3 years, and it's saying it shall be reviewed from time to time. I'm proposing, Chairman, that we ask that the legislation be reviewed every 5 years at a minimum, and I'm open to whether or not that's an appropriate time. And I'm also asking, Minister, that if there is a failure to bring the act for review within the 5 years, that the Minister be required to seek the permission of Parliament to extend that time and give reasons therefore.
okay, I think I agree with you, Senator Shireen Golden Campbell. So my future successors will need to. No. May I just say no? I would say subsection 2 should require that the act be reviewed at least every 5 years. Okay. And just put it like that. If we do it, review every 5 years. That's it. I don't think we should really, impose, because if you do that.
But then why put it in? Because it's not observed at all. And this is not the only legislation. It's something that people have criticized the Parliament for quite a number of times over the last decade and a half, certainly. I'm not trying to propose something to constrain a minister or ministry. When there are other competing priorities, it may not be the priority matter. But I'm simply saying, for the purposes of accountability to the people of Jamaica, that we at least require that the minister responsible explain to Parliament or issue some statement to Parliament as to why, if it is not going to be reviewed within the 5 years. That, Minister, is what I think our people deserve.
Ms. Eden.
Chair, thank you. It was just in relation to Section 43 and the discussion had, I just wanted to, the committee may wish to note that the obligation is by a committee of both houses of Parliament. So this provision is in an act of Parliament, and it is, the obligation isn't by reference to a committee of both houses of Parliament. And the timeline is only in respect of the first occasion on which it is to be reviewed. Thereafter, it is from time to time.
What is being suggested in subsection 2 is that it should be reviewed at least once every 5 years. Would that be appropriate, Ms. Eaton, to put it in subsection 2?
Chair, it is a matter of policy.
I don't have a difficulty that it should be reviewed at least once every 5 years. The review might well say there's no need to set up a committee. The act. To be frank with you, one of the reasons why this, for the last COVID intervened, okay? So not many things happened between 20 and 23 when it should have been reviewed. Since then, we have been collecting data from 24, 25, so we literally last year said we would review it as soon as possible. So to the extent that we were collecting data, and I keep my fingers crossed, it has been doing a good job. You know, the child diversion program has been fairly successful. So that we were, when we came to Parliament, the few weaknesses which we're trying to sort out now, we're trying to correct. It may well be that if we implement what we're now recommending, that in 5 years' time we can say it is working well, there's no need to do any further review. But I would agree with Senator Sharon Golden Campbell in put subsection 2 that it should be at least be reviewed once every 5 years. But I wouldn't impose any burden. If the burden would have to be in Parliament, you know, rather than.
Can I interrupt you a moment?
Sure,
because
go ahead,
I think that's clarity that Ms. Eaton just brought, and I thank her for it. The act is to be reviewed by a committee of both houses of Parliament appointed for the purpose. So I think she was trying to gently suggest to us that it's really not for the minister to come to Parliament and say the act must be reviewed, but our duty as parliamentarians to make the requisite, table the requisite motion for the review of the act, or to somehow stimulate the parliamentary system to put this on the agenda, and I thank her for that. Back in my court, Ms. Eaton, and I appreciate the correction.
Right, thanks. Minister Dana Dixon.
Yeah, thank you very much, Chair. I agree with the review every 5 years. There are a lot of pieces of legislations that need to be reviewed and that are not. I would not add the other part of the request, of the recommendation earlier. But my question for you, Chair, was that you had noted that, you know, after 5 years, you could do a review and it may come back and you may determine that there is no need for a committee. But in 43(1), it says the act shall be reviewed from time to time by a committee of both houses of Parliament appointed for the purpose. So we would have to set up a committee in order to do the review. And that is a part of where my hesitation is, given the quantum of laws that need reviewing. But I can live with it because it is something related to children, and I think that we need to often review legislation relating to children, but just noting that we would still have to set up the committee to even decide that we're not going to do much more.
No, Dan says yes.
Yes.
Dan says yes. In other words, once Parliament sets up that joint select committee, the committee may well listen to the various contributions from the different sectors, and after 2 or 3 meetings, agree that there's no need to have any review, any further review. So, but I think it's appropriate to at least say that the bill, the act, should be reviewed every 5 years, because you, as you quite rightly pointed out, Minister Dana Dixon, we're dealing with children. And, you know, we have to be very sensitive about the laws that, you know, pertain to children. I think Ms. Cuthbert-Flynn would like to say something. Go ahead, Ms. Cuthbert-Flynn.
Thank you, Minister. Thank you, Chair. Yes, I also want to register my approval of this and to agree with Senator Shireen Golden Campbell and Minister Dana Dixon that I think it is important to review, especially this piece of legislation, the fact, as you mentioned, that we're dealing with children. And, you know, when we look at some of the laws, even now, with the various fines from 19, how long, and we pretty much have to laugh at ourselves as parliamentarians that we've not And I do understand the constraints that we do have to review the piles of bills that we have to look at. But I think it's going to be important when we're dealing with children to make sure that we're reviewing, because things change, and a case may come up where we possibly didn't see happening, and we have to then make some changes. And I think it would be a good thing to review piece of legislation like this every 5 years. I'm not sure, however, again, the stipulation, but again, it was mentioned that a committee would have to be set up in Parliament to say, okay, we'll look at this, piece of legislation or not. So I want to register here that I'm in agreement with that.
Thank you, Minister Cuthbert-Flynn. I think there's consensus. We review the Act every 5 years. Just leave it at that. Now, in relation to the first schedule, an interesting point is noted. If those persons with the matrix will see that one of the recommendations from Jamaicans for Justice is that we should include cyber crimes. Now, Minister Dana Dixon, you might be interested, that we should put in the first schedule, the question of social media, that children, a number of countries are now banning children or make it unlawful for children to be hooked in on social media. And I can see where, this concept of cybercrime is something which we may well have to put into this child diversion, the schedule. Because I can tell you, from where I sit, I see children who seem to be more hooked on, their iPad rather than books. I don't know how we're going to manage this, but the issue really is how do we, and countries are now, they're now passing laws to control social media. I don't know if we want to go there, but let me hear your views. Go ahead.
Chair, I'm just going to put on my Minister of Information hat. The government at this time does not have any intention to ban social media. So I just want to make that very clear.
Not even for children?
Not even for children.
Okay.
There is some work being done to look at the impact of social media on our children, and the approach the government has articulated is that it's about public education and not really trying to do restrictions. So at this point, that is what the official government policy is in relation to that. But you did raise the issue of cybercrimes, which is a completely different thing. And I agree with you in terms of, given today's climate and actions that, we see what children are doing online, some of the cyberbullying that's taking place, which is really terrible. But those elements we do have to treat with in the ambit of the Act, but I would take that away from any discussions around bans on social media.
Right. I must admit, I should be aware of that. It's cybercrimes I was thinking of. Go ahead, Member Buchanan.
Chairman, you made reference to the tablet, and I must let you know that I am one who's advocating, and many times I reach out to the minister and beg her some tablets, and she says, what? But I'm always, my thought is that every child in this country should have a tablet, because it makes us competitive in the modern world. And there's a bad assumption that every child with a tablet who is not reading is not getting the information. But a lot of the programs are on the tablet that cause children to be much more advanced. What I will say is, though, I would have said earlier about the concept of the uncontrollable parent. We are taking away too much, we are removing responsibilities that parents are supposed to have. It cannot be that children live what they learn, they mimic, they repeat. So if you have parents who have no social media control, then you're going to see children acting out like that because they see what happened. What the government cannot do is to begin to try to regulate free speech, regulate how people accept, disseminate information. So we have to have a little bit more targeted conversations about what public education will look like and what responsible parenting will do. So I'm seeing in the legislation that perhaps it is the concept of child neglect that needs to be strengthened, because parents ought to be responsible for the conduct and actions as children while we make effort to divert them. I'm just making that clear.
My only concern, I'm not too sure that this is the act that we would put that in.
No, I'm just saying though, when we're having the conversations wherever it fits, we should focus on the diversion, focus on in terms of how we are reprogramming the minds of children who find themselves in conflict with the law. And if cyberbullying comes in, what schedule does it fit, and what type of program should we do to reintegrate and re-educate?
Well, Jamaican Justice suggests we put in Section 9 of the Cyber Crimes Act, malicious communication. I would support that, okay? Did we look at any other offenses that could be included in the first schedule, Ms.? Yes.
Grievous sexual assault, Minister. We do see that coming from the courts. And they come with the sexual intercourse with a person under 16, but the police cannot send it to child diversion directly because of the grievous sexual assault as well. So
okay, and that is also recommended by the Ministry of Education. So you would want to include those two, grievous sexual assault and cyber crimes. I would say we put in this cyber crimes generally, so that children, if into the first schedule. So Ms. Eden, go ahead, Ms. Eden.
Chair, thank you. If I recall the discussion pertaining to grievous sexual assault, that there is a range of factual circumstances that can constitute that offense. So there was a question as to who would be able to do that referral in respect of that offense, because there's a range of acts that may constitute the offense.
Well, the usual persons, the constable, usually the constable. In other words, if it is being done in the school, the guidance council may well have to speak to the constable, I mean, at one time I was saying that guidance counselors, principals, but I've withdrawn that position. It would be too wide. There's no doubt also that parents, at one time I said parents, but then the best approach is to filter it through the police and the DPP before it gets to child diversion. Okay, Ms. Eden? Sure.
I'm not hearing the conversation about possession simpliciter in relation to the firearms. And I'm prepared to sit here until 4 o'clock to advocate.
No, with due respect, though. As I said, we'd rather that goes on the Section 37. In other words, let it be a Section 37. I am aware that the Ministry of National Security suggested that it should not be included in the first schedule. I would like us to support that position, but to remind ourselves that under Section 37, it is possible.
But so
in other words, we do not, no, put another way.
Chairman, the purpose of child diversion, and I'll say this respectfully in the context, and this is no criticism on my counterparts before me, the firearm legislation, and we went painstakingly through an excellent reform for the expungement legislation. We've had conversations about this. It was badly drafted. Firearms, the firearm legislation. Just give me some leverage. If the child diversion is to mean anything, the message that is to be sent is that there is a space in law that there is something called social agency. We are well aware that there are adults who are using children, even children below the age of criminal responsibility, to lock firearms. Let's call it that.
And to carry.
And to carry. So if we are going to be in the business of being able to pull these children and divert them from this deviant behavior, possession simplicity has to be a space that we can divert them and put them in programs. If we leave it to the discretion under Section 37 in that contemplation, I'm afraid that there will be children who won't be able to benefit. And I don't want to get into the classism behavior, but to say that if we are diverting, I'm begging the committee to treat children as children, nothing more. Regardless of how some of them appear to be big, it is the mind that we are trying to reprogram. And I will say this, Chairman, before you interrupt me. I work in the criminal justice system. Some of the reasons that the youth is found in possession of a firearm, we have not begun to ventilate the lack of free will. And criminal responsibility is founded on autonomy, the freedom that I freely did a particular thing. You cannot be in communities where a don says you are responsible for locking the firearm because you're a talented football player or track and field and nobody is going to trouble you. And you're found in possession of a firearm.
But due respect, though, you're giving substance to sanction that behavior, with due respect. No, one second.
Mm-hmm.
If you say that you are going to allow that child diversion offense, then the Verdun will say, you won't be convicted, you just do it. No, one second. All I'm really saying is that in appropriate cases, the very same examples, if that child in confidence can say to the police or to the DPP, or in camera, in court, how they got possession of a box of ammunition and guns, then the child may well be put on a child diversion program under Section 37. But I would want it under the first schedule, which would, with due respect, be almost flying in the face of the firearms legislation. What I'm really saying, Minister Buchanan.
No, not a minister yet, but speaking to
what I'm really saying.
I received it.
Yeah, what I'm really saying, Member Buchanan, is we're saying the process should be that the court would come in once the child is found with a firearm or with ammunition. The most I would go is to say if the child was found with a toy gun. You understand? But your position that the child may well be forced to hide, to carry, to be in possession of a firearm would be buttressing the don, so-called don in the area, to say, you can do it. If they find you, you're going to child diversion. So I would not really support the position to say that a child who is found in possession, simplicity, of ammunition or a gun, that they automatically go to child diversion. I would say let the court make a decision under Section 37.
Minister, I won't detain you, but I can tell you, let me start. Jamaica is a high crime society. Justice must appear and seem to be done. The judges will never start to hand out goodies as if it's Santa Claus at Christmas time and pass the olive branch. It is the duty of the legislator to state the intention of how, in relation to children, what do we want for the future of our children? I sit here and I'm not pontificating, I promise you. At 47, Chairman, I am still dealing with the past of convictions that have nothing to do with firearms. If you want the best version of a Jamaican child to be better than me, if at all there is any good in me, and you see it, Chairman, I've interfaced with you many times. But if even a spark of intelligence, a spark of a son and daughter of this country to be the best versions of themselves, all I'm asking is to empower the JCF to drape up a boy, take the gun from him, and let the Don realize that as you can buy enough guns that we can confiscate. The court's primary intention is to get guns off of the street, and especially out of the hands of children. Possession simpliciter is not saying to the court that if a juvenile decides to go on a shootout, that they should be given child diversion. I'm saying there are many reasons why possession simpliciter should not be the basis upon which a person who has not even gained the right to vote, his life is messed up for the rest of his life.
No, I understand.
We're fighting. All I'm begging for is to treat children as children. There was a time when my mother would tell me which to go pick my own switch for her to punish me. Those days are long gone, but it means something, because if we spare the rod, we spoil the child. If we spare the diversion, we're going to just have worthless criminals who may not have the opportunities of families and role models.
Always bear in mind, we're not excluding it.
No, but I'm doubling down, Chairman. I
Let me hear the other views. Let me hear the views of the other
colleagues to back
no,
me
let
on
me hear
this
the
one,
views of the other.
I'm thinking about the children, and I just won't stop. The marshal will have to come for me because I want people to understand that possession simpliciter. I will yield to my colleagues.
All right, no, you go ahead, Minister Dalrymple.
Yes, thank you, Chairman. I really want to support. I know what you're saying. I have seen it with children, and really, it is possession simpliciter. As he says, you want the guns off. And remember that in certain societies in this country, when the Don says, you hold this, a young child sometimes fears for his own life, or if he doesn't hold it.
And I'm saying...
And we are saying, but what he says is true. With the state of things now, if it is not included and it goes to the court, we still practice in the courts. They are not going to get the leniency at all. They are not going to get it. So we have to decide whether or not we really want to. I know it is touch and go, but we are not saying if the child has done something,
So your view would be to put possession simpliciter in the first schedule.
Yes.
We get that.
Knowing the power of the Dons and how they operate too.
Let me just take Senator Donna Scott Motley, and then I would like to hear from Ms. Judith Cuthbert Flynn too, because the Ministry of National Security object to it being a part of the first schedule. Go ahead, Senator Scott Motley.
I have always had reservations about the Firearms Act. I think that there was a definite overreach when that act was being developed. But I have a little concern about our approach today, in the sense that we certainly don't have any information, we don't have any data as to what exactly has been happening in the courts in terms of whether children have been coming before the courts charged with illegal possession of firearms. I do agree that there should be some guidance to the judiciary. Whether or not it should be a part of the schedule is what concerns me, because our discussion does disclose that the judges have discretion. And I wonder if we should not, if it is not more, that the judges should be aware of the policy of the administration as it pertains to children, rather than for us to have it in the schedule. Because, Minister, to be very frank, I do share your concern that this provision might be abused somewhat by those who have a lot of influence. Mm-hmm. This is such an important discussion. It points to the real need for a revision of the Firearms Act, which we have been promised. But it requires significant analysis and deliberation. And I wouldn't want to make the recommendation without having the appropriate documentation to guide me. So maybe it is that I'm not coming down on either side, Minister, but a change like this is deserving of a degree of discussion and analysis, is what I'm saying. And within the context of the other changes which we need to see in the firearms legislation.
Thank you very much, Senator Donna Scott Motley. One second.
All right, so good morning, everyone, and good morning, Chairman.
Could you state your name for
So I'm Lloyd Tilwellin from CPFSA, Legal Officer. All right, so I do understand what Council is saying. However, how is it that these children would really all right, so the truth is that they would benefit from the child diversion program, but the cycle, so is it that we are going to take these children out of the community, right? Because once they go back to the community, you know, the possibility exists that the cycle will continue, right? And then my colleague was also saying, if it is that the Dons know that these children will be going on the child diversion program and they will not be charged, then in essence, you know, they will do it again, right? So they will continue to impose, you know, this on them for them to do. And then, you know, Mrs. don't remember her name.
Marissa Dalrymple.
Right. She indicated that, you know, they are children, so they are very impressionable, right? So once, you know, the Don comes to them and says, you know, you have to do this, then the fact that the Don knows that they won't get it, there will be no implication, basically, then the children will continue. So it will be a continuous cycle if it is that the children are not taken out of these communities. So that is the issue that I'm having with putting, you know, this offense in the first schedule. So there it's going to be problematic.
One second. Ms. Cuthbert-Flynn, are you there?
Yes, Chairman, I am here. And, you know, this is a very touchy subject, and I hear my colleagues mentioning several things. But I will have to agree with MNSP. And I'm sure, you know, Senator Scott Mott mentioned about data. I am sure that they would have collected or looked at data before making this recommendation that it is kept separate from the Child Diversion Act. I also believe, you know, and I know that we're looking right now at the Firearms Act and to make some changes. However, I think we have to set a standard. You know, you talk about Member Buchanan mentioned about parents earlier and their responsibility. But we have to set a standard. We do have a gun problem in Jamaica. And so with this proliferation of guns and, you know, just our culture, I think a standard has to be set. And these children, they might be young, but I think they all know right from wrong. And as simply put, the Dons in these communities will know that there's really no punishment. If it is that they ask them to lock the guns or to carry the guns or to hide it or what have you, there'll be no punishment for them. It'll be a child diversion matter, and that is it. So I think we have to look at setting a standard and making sure that we keep to that standard. And while I may, you know, empathize and be sympathetic to children possibly, you know, getting in serious trouble for a gun crime, I think it is important right now in our society to really make sure that this kind of an act, this matter is not a child diversion matter that is kept separate. And so that is my point of view on the matter.
Thank you very much, Minister Cuthbert-Flynn. Yes, Mr. Member Buchanan.
Chairman, I know I speak from a place of a lot of emotions, and then people ask for data. I'm not currying favor, the very act that we're speaking of, and I will say this with the greatest amount of respect, the recommendation from the Ministry of National Security is a plea to this very committee to, in relation to firearms, not treat children as children. Section 37 says the judge has the discretion to treat every matter when it comes to a child for diversion. The act says, and I read, in the event of any inconsistency between a provision of this act and any other law other than the Constitution of Jamaica, the provisions of this act shall prevail to the extent of the inconsistency. There is no data that I need to say that to preserve the human capital of a child in Jamaica, which I think is the most important commodity for the future of this country. We have ministers and prime ministers asking women to have children to preserve the future of this country. And I'm simply saying, I practice in the criminal courts. Judges sit and say, Mr. Buchanan, my hands are tied. Ms. Dalrymple, my hands are tied. In camera, judges says, my hands are tied. And they issue certificates to preserve young students who have the brightest future, that this will prevent them. And I am saying as the country is watching, treat our children in Jamaica as you would do a child in England or the United States. Give them the defense of affluenza. Treat them as if they were your child. And I can say this to you, I can't think of a country when I was a child that allowed me to be a member of parliament to say, don't give the next man's son the opportunity. It's not me closing doors. I'm simply asking this committee to open it. No, I don't know what data you could need to prevent. And let me respond to the young lady. The child diversion, we had many conversations about whether or not we should afford 1 strike, 2 strike, 3 strike for the child who diverts and does the same crime over and over. The purpose of child diversion is to give them a chance. No, but some need 1, some need 2, but I'm simply saying in relation to possession simplicity, if we want to get guns off the streets, if we understand what is happening on the ground, every child is a child. And if we're not seeing it that way in child diversion, I don't know what I'm doing here.
No, but with due respect, Member Buchanan, we're not disagreeing yet, totally. You know. The difference you and I are having, let me just say this, is that if you put it in the first schedule, it's almost automatic that it can be referred to child diversion. What I'm saying is, allow it under Section 37, where in appropriate cases, where it is clear that the child is being used, or the child got possession by accident or negligent, then it can be put in the child diversion program. One second. Because the child may well deliberately want to control a gun. A 16-year-old may well deliberately want to control a gun. And having been found with the gun, he says, put me on child diversion, or automatically it has to go to child diversion. And my answer is, that may not be an appropriate case for child diversion. Because, one second, it is a deliberate act of the child, maybe even to fire a gun, okay? Gun salute, as the case may be. All I'm really saying is that once it involves what is the most dangerous thing in Jamaica today, gun crimes, that leave it to the judge's discretion to look at the nature and circumstances to determine whether it can be referred to child diversion under Section 37. But if you just put it there and say that guns simpliciter, or possession of a gun or ammunition simpliciter, then, you know, the discretion of the judge does not even come into consideration the nature and circumstances of how the child got the gun. It may not even be considered. No, but you're sending it straight to child diversion, and I'm not too sure I can support that.
Chairman, there's not one child there. We have not even gone. This committee has not accepted my proposal of mandatory child diversion. So I don't know, I cannot follow the logic
No,
that
no,
you
no,
are saying.
no.
Here's why I'm saying this. Notwithstanding, as the child diversion currently is, we still have to beg a judge to send sex with a person under the age of 16 to child diversion, because if the circumstances don't require it. And I'm saying we're starting with the general rule that is a child diversion offense. We will identify the miscreants, and I leave it to the judges and the constable and the prosecutor to have the wisdom when that time comes. But if we start to say, I cannot figure in which society that a person who is a child who finds himself with drugs get to move on, because drugs are very dangerous, and they get to get their records expunged, but not the child in possession of a firearm. If we cannot expunge it, why are we convicting them to condemn them for the rest of their lives? At least in Jamaica, when a young person, and I can speak for myself, find themselves with drugs, they get to have their convictions quashed and expunged, and they get to walk up and down and behave like they're somebody. No, it used to happen, and in 2014 it stopped. I was a child, and I was the beneficiary of an expungement.
Let's not get into the personal.
No, because it is also a situation where we are saying that deviant behavior can make the schedule, but possession simplicity can't. I will ask, like I learn fast. I will ask, like my colleague, Senator Golden Campbell, and ask for the Attorney General to provide an opinion and the necessary data to be brought to this committee so that we can make an informed decision.
This is a straightforward policy position, which this committee has to recommend.
Well then, Chairman, back me on this one.
No.
Just this one. This one possession simplicity.
Member Buchanan, you have to understand, I have been more involved in the criminal justice system than you.
That is true.
And I can tell you, walking the streets across the inner city communities, the people who carry the guns for the criminals are the women and the children. You don't really find the gunman, only at night, them bring it out. But the children and the women carry the guns. Right, 1 second, let me finish. This country is overwhelmed with gun crimes. At one time, 80% of the killings were done by guns. I think it has now dropped below 70%. We have too many guns in this country. And it's clear to me that even possession of guns simplicity is a serious indictment on our society. Fine? I think this committee would be sending the wrong signal to say because a child is a person in possession of a gun, could be an M16, you know, could be an M16 and carrying on boxes of gun in their yard, as the case may be. And the child, you go into a home, and the child is the only one sitting on the box of ammunition or on the box of guns. Fine? Because, Member Buchanan, I have to tell you, in many inner city communities, they flash gun every night, you know. They flash gun around every night. As far as they're concerned, and even the children, them firing guns. We cannot now in this parliament say that because a child is found with a gun, we send that child immediately to child diversion. My view is that there are appropriate cases, undoubtedly, in which the child could benefit from a child diversion program where he or she has been found with it. But it should not be a general rule. So if we can get all the evidence, you can listen to the police officers, you can go around into communities, and I'm telling you, Member Buchanan, that the Parliament wouldn't support it. I can tell you that. The Parliament would not support us to put
Chairman,
first.
Chairman, you know, Chairman, we keep talking about inner city, But you have rural communities where youngsters are also being caught with guns, and they don't necessarily have good intention having those guns. So, I mean, what is a message that we would send to say, if it is that you're caught with the possession of an illegal weapon, that you are now just going to be sent to child diversion? I don't think we're going to be sending the right message. And as you said, we have a gun culture in Jamaica.
Yes.
And yes, Member Buchanan, you're saying, you know, it might be a harsh reality for some of these youngsters to, you know, not be able to, you know, get this kind of crime expunged, you know, like you would if it's a possession of illegal drugs. But again, I believe that this kind of a crime, possession of firearm, illegal firearm, should not be a matter where it's just sent to child diversion just like that.
Member Buchanan, may I make a point? We can close this off by saying, in the report, the committee is concerned, and make it that the committee can be, say, divided, if you want to put it that way.
You know, Chairman.
Without taking a vote. No, one second. Because I can assure you, I cannot see how we could put this generally in the first schedule without not putting a whole heap of other crimes in the first schedule.
No, well, you know.
See, so I have to be very careful.
Chairman, I want to explain something to you, and I will remain silent after I make this statement. I dream of a Jamaica where we treat children as children and nothing further. But just understand that we speak about gun crimes a lot of times, and these gun crimes are a result, the empowerment of possession of a firearm, are results of being in homes where persons are sexually molested. Crimes that are not reported. And I'm just letting you know that we have accepted a lot of deviant behavior and said this is okay. But I'm saying possession simpliciter, which calls for a more important investigation as to why children. The trauma, we speak about it and say we're in the trenches, you know, but you don't understand the trauma of living rural, living poor, and he who feels it knows it. I am just talking up for, as the opposition spokesperson on youth and human rights, I know what they feel. I know what it is to have to say, I'm a big man because people say I'm a big man. If somebody say you're careless, you say, well, I might as well be careless. There's nobody speaking positivity into the lives of the future of this nation. So guess what? If the parliament doesn't want, or this committee doesn't want to agree with me, and we don't want to put it to a vote, and we don't want to be brave enough to protect our children, because if the parliament give me the power, I will use my belt, and every man that think him is a bad man and him is 16, give me the power to kick off them face and don't arrest me. And we won't need diversion. But because I must be a distinguished gentleman, and I must say, well, let me sit in my small space and not protect children, I will yield, Chairman. But I'm hurt by this. I must tell you, my soul is hurting by this.
But you see, what is happening is that you want all or nothing, or all. I am saying, what you're pleading, Member Buchanan, is possible. But it is only possible in what I would consider appropriate circumstances. I'm sure you're aware, Member Buchanan, what happened on the weekend in Thailand, where a 14-year-old boy just killed about 7 teachers and killed its grandparents. He was in possession of a gun, 14-year-old in Thailand. You see it across the United States where children with guns. Fortunately, we don't have it here so far, but we could never in Jamaica send a signal that we are going to be unusually lenient because the possession was by a child. I'm not saying that in appropriate cases they should not be considered. But I would just want to ask the clerk, no, we'll get the data and we'll find out.
But Chairman, I have had my hand up for some time.
Go ahead, Senator Scott.
And I really would respectfully ask to be heard.
Sure, go ahead. Again.
I don't think that this is a situation where the judges can say my hands are tied.
No.
I think the legislation allows them, if they hear the circumstances under which a child comes into possession of the firearm, the legislation allows them to send it to child diversion. This discretion on the part of the judges is of extreme significance.
Very.
And I believe that the judges should be urged to utilize it in the appropriate circumstances. As someone who does not support mandatory sentencing, I think the commendable thing about the legislation is that it gives the judiciary that opportunity. I could not, and I know it's going to surprise some people, but I could not support it being automatic that a child who is found in possession of a firearm be automatically sent to child diversion. We have to contemplate, our society is advancing. These recommendations which we are making for the amendment of the Child Diversion Act are significant, and it will impact children considerably. But I must tell my colleague that I regret, but that I cannot support this quantum leap, but that I implore that all the mechanisms available be used to make the judiciary know that they have an option, even in a firearm offense.
Thank you very much, Senator Scott.
I agree with you, Senator.
Go ahead.
And that is where we possibly should take this, where we allow or put into the law, where the judiciary has a hand in this, a say in this. You know, I can say that I was held up at gunpoint with a Glock, and it was a teenager who did this. So, I mean, we can't just simply say, oh, you know, just send this person to child diversion just because of a simple possession. And so I'm in total agreement. I cannot agree just, you know, wholesomely just saying that this should be a child diversion, you know, situation.
Thanks.
And again, Chairman, I'm in agreement with you and also Senator
Minister Cuthbert-Flynn. Senator Sherin Golden-Campbell.
Thank you, Chairman. And just very quickly, Senator Scott Motley, I think, has raised the issue, and I want to seek some clarity because I believe it was Miss Eaton who reminded us that a diversion offense, the meaning of a diversion offense includes not just offenses in the first schedule, but any other offense for which a court may make an order referring the child to participate in a diversion program.
Under Section 37.
My question is to the team, is there, and I don't have it in front of me, I can't remember from the top of my head, but is there something in the Firearms Prohibition and Prevention, I can't remember the full name of it, the Firearms Act, that exempts the Firearms Act from the provisions of the Child Diversion Act? That's my first question. I want to make a comment though, and I really do empathize with my colleague, Member Buchanan. I understand where he's coming from. I understand where his heart is placed in his proposal to this committee. And I also appreciate the comments of my colleagues. But if you would just permit me, you know, it's exactly these kinds of conversations that I'm asking us to guard against. We really cannot sit and make policy in a parliamentary committee on our feelings and anecdotes. So if it is that we are considering a proposal, the ask of the committee or the ask from the committee really should be to ask the relevant department, ministry, office, whatever, to do the research to inform the committee. These are emotive issues. You know, and we all have a personal viewpoint. We all have a moral compass that we are making a determination as to how we can help our nation's youth. But please let us have these discussions by looking at what the measured circumstances are, what the impacts are in the court system, and what the outcomes are for these kinds of youth. Not just about the youth that we see and we know it's a bad situation with one or two. We cannot continue to make law that way. So if the team could answer my question in relation to the Firearms Act, is there a provision in the Firearms Act that takes it out of the purview of the Child Diversion Act? If it does not, then I believe what Senator Scott Motley was saying, and if I could just underscore and make it a little louder, is that the judge already has the discretion. So please guide me on that. I'm grateful.
All right, thanks. Ms. Wright or Ms. Eaton, could you help on that question? To the best of my knowledge, the Firearms Act does not exclude the child diversion, but could you check on it for me, please? You wanted to ask just name and department, sorry.
My name is Trevon Chu, Crown Counsel at the Ministry of Education, Skills, Youth and Information. With regarding the point that we are discussing, just a few points I want to make. One, the serious nature of offenses are considered in other spheres, other areas of law. When we look at the Bail Act, we see where a gun being used is considered in the application for bail or the consideration for bail, as well as other areas as well. So when we look at the serious nature of an offense, I believe it applies to the Child Diversion Act as well. The use or possession of a firearm is a serious offense. And what we want to make clear is that the child is not shut out of the Child Diversion Act. They're not shut out. It is who will exercise that discretion to send them. And we are saying that that person should be the court, and it should stay within the court. And I also want to indicate that when the matter is determined or decided by the court, whether the child should be referred, it allows for a holistic view, a holistic review of the situations in the matter. So we may see where, I think my friend was mentioning that the child may be forced to bring a gun. My friend here was also indicating that Dons may know that they can give the gun once more to the child. The judge would be able to look at all the circumstances of the case and make not only an order with regards to child diversion, but there are other things that may come into play. The child may have to be referred to CPFSA perhaps. They might be become a child in need of care and protection, and that's something that a judge can consider. So I believe the discretion should remain with the judge.
Right.
The courts, rather.
I would just like to remind colleagues, any offense in the child diversion schedule, a constable can do about 4 things. Issue an informal warning, issue a formal warning, issue a caution, or charge a child. So that it is understood that within those 4 provisions, depending on the nature and seriousness of the offense, the constable can do that. If the constable charges a child, then it may well be the DPP has to determine whether they send it to child diversion, or if, the child declare innocence, then it may well go to court. I don't believe that it should be within the province of the police officer, or for that matter, the clerk of court, to make that decision that a person who's found with a gun can be sent to child diversion. Guns are serious offenses in Jamaica, and I believe as you quite rightly say, attorney from education, the circumstances must be looked at carefully. And that is where a judge listening to the circumstances is in the best position to exercise a discretion whether or not that child should be sent to child diversion. And therefore, I would say the consensus as I see it is that it should not go in the first schedule. It should, as the Senators Scott Motley and Shereen Golden Campbell says, it should come under Section 37 of the Act, which provides that notwithstanding the diversion offenses specified in the first schedule, a court may make a child diversion referral order in respect of any other offense in the interests of justice. So I would want to leave it there for the moment. So that is it. You wanted to say something?
Hearing me? All right. So Ms. Chu, she would have indicated that it's a very, very serious offense, and you would have said it yourself. And the court shows how serious this offense is, you know, because in the court system you have what is called a differentiated case management. And that, I think, for offenses in relation to a gun, DCM-6 is a tier that they usually use. And that really means that the matter is directly transferred from the parish court to the Supreme Court. So it is something that is done immediately. So it just shows that, you know, the gravity of these offenses.
Thank you very much. Ms. Masado?
Thank you, Chair. I am not aware of any section or any provision in the new firearms legislation that deal with child diversion, but I am just going to read section 100. It says, proceedings against a person under the age of 18 years in respect of any offense under this act alleged to have been committed by that person shall be dealt with in accordance with the Child Care and Protection Act or the Gun Court Act, as the case may require.
So it does include child diversion, but it includes even the Child Care and Protection Act. So that even the Ministry of Education, at the moment, the child does not have to be convicted. It can go to Child Care and Protection Act, okay? I think we have, you wanted to say something?
Just to point out that there are two provisions in the Act that are of note for this particular discussion. So we would have discussed Section 37, which has the overriding provision for the judge's discretion. But on the first schedule as well, that lists the offenses, there's something in Section 10 that says, an offense under any other enactment for which the penalty is imprisonment for a term not exceeding 3 years. So when we're looking at the Firearms Act, the minimum mandatory may exceed 3 years. But then is it that Section 37 would override that particular provision now to say, even though if you're reading the schedule, the firearms provisions would not fall within the schedule, can the judge then still rely on Section 37?
Which was the first one? Which section you read?
So I'm reading from, so we had gone through Section 37
yeah,
before,
but which
so
was
I'm
the
now
one you
reading
said about
from
3 years?
the first schedule, that is the diversion offenses, so the first schedule of the Diversion Act. So if you look at number 10, which is the last thing on the first schedule, it states that an offense under any other enactment for which the penalty is imprisonment for a term not exceeding 3 years.
Section 37 overrides section the first
So
schedule.
I just wanted to point
no, it's
that
clear.
out, even though it's
because
there. Yeah.
37 refer to notwithstanding the first schedule. Okay. All right, colleagues, I think we have done a great job. Huh? We have some, with the matrix, we have some matters arising from the last meeting, and I think we had a full referral from Ms. Masado and also from law reform. I have not seen that law reform. It came in, where is it? You have it? Give me a copy. Ms. Senator Shereen Golden Campbell, would you like to, have you had a chance to look at both matters? You have had a chance?
Chairman, I have had a chance to look at the Attorney General's opinion.
Right.
I unfortunately have not been able to digest the Legal Reform Department's opinion. And I still have some concerns in relation to that? Is it that we're going to take this matter now, or we're going to defer the matter?
I don't know if it is appropriate because persons have not read them. I have not read.
Yeah.
I read the.
I too would appreciate a little extra time with the opinions that I have, because I have also sought the opinion of a senior colleague in the matter that I would wish to look at and to perhaps share with the committee later on.
Sure. Colleagues, I know we're on holidays, but I wouldn't mind if we could meet again, you know. Well, could
Chairman, can I just ask for that meeting to be after the 24th of August?
No, we're thinking early in September.
Oh, very well, thank you.
But early in September, by then, we're hoping the minutes, Mr. Nash will have finished the minutes, start a draft report, because we really, really would like the thing to go forward. In the interim, I'm going to try, Member Buchanan, to get from the police how many youngsters, some data on the children, all right? All right, go ahead.
I won't be winded. I'm just, you know, in relation to this particular point, I understand the magnitude and seriousness of offenses generally. And I do appreciate the doctrine of separation of powers. But maybe it's the first, if it has ever been done, I would wish that if one judge will have one statement or data provided from court administrative services in relation to this. It is as if we are speaking for judges and speaking about them, but I don't see nothing, no recommendation from the judge. And for this particular point, if it is at all possible, please don't send me to go down to Supreme Court and knock on doors, because I will do it.
I think you will appreciate, you know, this minister never discussed with judges and ask them for
I
opinion.
understand that, but
I
think maybe it's for my own edification.
I know every single one of them from the top to the bottom.
Well,
but not one of them will ever tell you I discuss any matter with them.
No, I'm just saying, maybe for public education and where we have gone in terms of the judiciary's contribution in standing firm in relation to their interpretation on the very legislation that we pass, whether or not how they have perceived and interpreted what we have before them.
You know that even after our first session, in which I indicated that I thought the judges were incorrect in holding the party guilty, the Chief Justice came out and said his interpretation of the law is that the person, they have to plead guilty, which I understand.
Which is why...
And this is why we accept that we have to change the legislation so that ambiguity, not ambiguity, it's clear that the law does speak of accepting responsibility as a guilty plea. Or for that matter, in section 33, it spoke about pleading guilty and so on. So
perhaps the middle ground then, Chairman, is to have section 37, as you said, to be drafted in such a way that judges know what power they're exercising, because the statement that hurts me is this: my hands are tied, notwithstanding persons saying that judges have this overwhelming authority.
No, I'm not too sure.
Even where things are in the first schedule, there are judges that's not diverting, it's still their discretion.
No, but you know, Member Buchanan.
And the drafters are here, they can tell you.
No, you know, Member Buchanan, I think we must not ignore the good sense of our judges. In other words, I would hate to think that in spite of section 37, that a judge would put a charge of murder to child diversion. It just don't make sense. You agree with me? So we're looking, when you say any other offense, it certainly excludes some. it certainly, I can't see a judge.
Chairman.
I can't see a judge, in all sincerity, where the person is charged with murder, say that it must go to child diversion. You understand?
Chairman,
yes.
Chairman,
yes.
Could some concerning things are being said. First of all, I think we have to be very mindful of the separation of powers.
Absolutely.
Doctrine. It is not appropriate for any judicial officer to opine on what the Parliament is deliberating.
We have to be careful.
In making of law. And as much as I agree their perspective would be very useful, it would be most inappropriate because at the end of the day, they are the ones who have to interpret what we write. Now, this matter about the guidance of the judges in relation to certainly the guilty plea issue, acceptance of responsibility concept, which I suspect we will talk more about as we talk about the opinions of the Attorney General and the Legal Reform Department, and what I will share with the committee in due course. Judges are not sitting in the minds of parliamentarians. Their first point of call is to look at the plain language of what is written in the law. And where that is a bit obscure or ambiguous, they might look towards Parliament's intent. But we have to write precise law. So if it is that we have the feedback that this thing is being interpreted in a way that we do not intend, then we have a duty, not just an incidental one, but we have a duty to correct it, and this is a place for that.
Thanks, Senator Sharon Golden Campbell. So, colleagues, I think we have come to the end of the review, subject to dealing with several of these consequential matters from the discussions, okay? So we're going to try and set a meeting for the very early, hopefully the first week of September before Parliament begins. I don't know when Parliament is to begin. But maybe, what date is the 1st of September? Could you just... why don't we try for the 2nd of September, the Wednesday morning? It's Mr. Nash, 2nd of September. Wednesday the 2nd of September. Huh? Sure. From the Attorney General's Chambers referral, Ms. Masada's 18-page matters, one of the things I would really like us to consider going forward, where we have these provisions in Section 22 in particular, where the informal warning, the warning and the caution, that especially the informal warning and the formal warning, that it is noted by the constable to the Child Diversion Office. My view, and I would want Ms. Eaton to note it, that we want to, we discussed it last time, that instead of just noting it, it should be referred to the Child Diversion Committee. So for the Child Diversion Committee to take such action as it sees fit, as the case may be. It may well be that in the case of the informal warning, it is a simplicity offense. But at least the Child Diversion Office should be able to interview the child and make sure that the child is not on the wrong path. So even all of them, once the child is in conflict with the law, the Child Diversion Office should be aware and take such action, even take none. But they must be not only noted. Sure.
So I'm so sorry. Can I suggest that we table that matter for the discussion on the opinions? Because I'm having a difficulty agreeing with you. And well, I think it is actually the subject of the opinions that were done. So before we give instructions to the drafter, let's have the discussion in September.
Not a problem. So we'll do it on September the 2nd. Yes. Yeah, go ahead.
And Chairman, if I could, can I just ask, I'm noting, and I could be wrong, that the Parliament, there hasn't been a publication of this meeting on the usual channels. Am I correct? And if so, can we get an explanation from the Parliament as to why?
I have no idea. Is it on PBCJ today?
I'm not seeing it, Chairman, nor on GIS.
It's on. I understand, Senator Sharon Golden Campbell, that it is on. It is on.
On the internet, on YouTube, or just on the TV station?
PBCJ and the internet.
Okay.
Okay.
All right. Thank you.
I understand that the first week of September, there is actually a conference. But we don't have to be there. I know, it is. Could we? It's a regional conference. I mean, it's invited persons. It's a regional conference of the members of the speaker and deputy speaker. And okay, I don't know if we can go any further. So we'll find a date in sometime in early September to wrap up. Okay. And also, Mr. Nash, to table the 2 reports, and I think there's going to be a third one. Sorry? And a third opinion, hopefully in another week or 2. All right. Because I have just got the law reform report, okay? Opinion, sorry. Thanks again, everyone, and I would like to thank everybody for a very fruitful discussion, and we look forward to hopefully wrapping up over the next. And we're asking Mr. Nash, please get all the minutes available for that first week. And a draft of the report, no, it's a semi-draft or a draft before the real draft, because we want a final draft in September. Thanks, everyone. Meeting adjourned.
Welcome to Wild World at the Welcome to Wild World at the San Diego Zoo.
Hey everybody, Rick Schwartz here, and today we're at Utah's Hogle Zoo, and we are in for a treat. I'm meeting up with Dr. Erica, and she's going to do some house calls with some of the animals, also known as veterinary rounds. Let's go see if she's ready. Hey Dr. Erica, ready to go do some rounds?
Hey Rick, I've got some interesting animal cases to check on. Let me grab my radio.
Cool. So which elephants are we going to see today?
So Christy, who's 29, she's the mom, and Zuri, who's 6.
Cool.
Hi guys, welcome. Come on in. Hey Lauren, thanks. So what we're going to do today is we're going to weigh the elephants on the scale.
And I'm guessing that's a pretty big scale then.
Yes, we have to weigh animals that are almost 8,000 pounds, so it's quite large.
Okay, so if I were to get on the scale, either before or after the elephants at the same time, would it even pick up my weight?
I think it would. We'll have to see though.
All right, I had a pretty big breakfast. We'll see.
Okay, let's bring Christy on the scale.
Excellent. So now wait a minute. The bottom here is all scale?
Yeah, it's pretty amazing. So this whole bottom part, when they come on, you'll see she'll bring her whole body on it, and then we weigh her.
Very cool.
Good girl. Good girl, Trump. Good girl. Steady. Good girl. Open. Good. Steady. That's a good girl.
All right, so how much does she weigh?
Let's see, she's coming in about 8,040 pounds. Is that a good weight for her?
That's a perfect weight for her because she is an adult elephant and her body condition looks great.
Good to hear.
So now I've heard that elephants can fluctuate sometimes a couple hundred pounds in their weight just in a day. Is that true?
That's absolutely true because first of all, they eat a couple hundred pounds a day. And then if you think about what comes in, what comes out.
So a couple hundred pounds of poop?
A couple hundred pounds of poop.
Wow.
It's pretty impressive, huh?
Yeah, it is. Okay, last question. When's it my turn to get on the scale?
Pretty soon.
Let's do it right now.
All right, let's get Christy out first.
Yeah.
Okay. All right, how much?
196, Rick.
That's cool. I weigh as much as elephant poop. Well, thank you, Lauren, so much for letting us kind of check out the health check for the elephants. But I heard we're going to go see a relative of the elephant next.
Exactly, the Hyrax.
Excellent.
Nice to meet you. Maybe cut back on the M&Ms.
Got it. Maybe so. Nice to meet you, too.
See you later. Bye.
Bye, Lauren. Thanks.
I don't know what she's talking about.
Rick, I thought you were supposed to cut back. Brittany, we're on our way from elephants. You ready for us?
Hey, Dr. Erica, we'll be waiting.
I was just reading about the Hyrax. Apparently, they're directly related to elephants because the tooth structure of the Hyrax is the same as the elephant, just smaller, and same as the foot structure and the forearms. So I never knew that. It's pretty cool.
You know, that's what makes my job as a zoo veterinarian so interesting, because today we saw an 8,000-pound elephant, and now we're going to see how much the relative, the Hyrax, weighs.
That is so cool. Why is it important that we get weights on animals in zoos?
Really, so we can make sure they're healthy, make sure they're getting enough nutrition, and we want to know if an animal's getting too heavy or too thin, so we can make a proper nutritional adjustment.
So I see the keepers in there doing a lot of training to get the animals on the scale. Why is that?
Brittany and Janice have a really good relationship with these Hyrax, and they will make it positive. They get a little sweet potato and the blow of a whistle when they do something right.
So the sweet potato not only tastes good, it's just part of their normal